Mr. Speaker, fellow parliamentarians, as Trinidad and Tobago moves towards the introduction of a parole system in the not-too-distant future, the importance of an electronic monitoring program will become even more apparent. Electronic monitoring programs aid probation and parole officers in monitoring and managing offenders' behavior in the community. It changes the nature of the supervisor-participant relationship and provides an objective, reliable basis upon which sanctions such as tightened home detention and rewards such as less restrictive home detention can be based. Moreover, Mr. Speaker, the enhanced level of supervisory control beyond that which is afforded by direct human contact alone augments offender accountability and ultimately has the potential to reduce the likelihood of reoffending. This bill then seeks to make provision for the introduction of electronic monitoring in Trinidad and Tobago at different stages of the criminal justice process, as well as to make it a condition of a protection order granted under Section 5 of the Domestic Violence Act, Chapter 45, number 56. Mr. Speaker, our government is taking a stand against domestic violence. This by strengthening the protection orders issued by our courts through the use of electronic monitoring systems. We have all heard of unfortunate incidents where victims of domestic violence, in particular our women folk, have received the protection of the state via a protection order, and yet suffer repeated violence and in some cases death at the hands of the very abuser against whom such an order was obtained. In fact, Mr. Speaker, prominent attorney Lynette Seabaran Sweet, in a Guardian article of January the 16th, 2011, entitled "The Problem with Protection Orders," noted, and I quote, "The problem with the machinery of the protection order is that society often leaves the battered woman on her own to attempt to enforce the order." Seabaran Sweet went on to lament, "We all know that a piece of paper cannot really protect anybody, especially if you're dealing with somebody who has no respect for the law." She further called for us as a society to go beyond the protection order and recommend the introduction of interagency protocols to define specific roles for all stakeholders in a situation of domestic violence, including the court and the police. Mr. Speaker, our government has heard her. Our government has heard the pleas of victims and activists alike, and we view electronic monitoring as a perfect complement to the current system of protection orders. By making use of this technology, more responsibility is placed on the offender to comply, I repeat, to comply with a protection order. The police are also provided with a better means of enforcing protection orders, as electronic monitoring would facilitate law enforcement's ability to know when respondents have violated protection orders by entering exclusion zones and would allow police to properly respond to the respondent's violation and provide the necessary evidence to the prosecution for the laying of criminal charges. It would also serve, Mr. Speaker, to allow for an early alert and warning to a woman who is living in fear that the person against whom a protection order has been made is on his way. Women live in this fear, and we want to protect them so that whenever the man against whom the order is made, or the woman against whom the order is made, because I know of men getting protection orders against their husbands, against their wives. I beg your pardon. It happens. And perhaps men getting protection orders against their men. That is all part of the formula. It's the world that we live in. They will have advance notice to look out, to go in and close their door quick. Yes, I'm told that it is unparliamentary, but I think I have moved out of the days of squiredom into the 21st century. And that is why I am seeking, Mr. Speaker, to bring our laws up into the 21st century. A matter that those on the other side had their time to do and they did not. You know? Please. This initiative, Mr. Speaker, will go a long way towards returning liberty to victims of domestic violence as well as to their children. This bill was adapted from the Bahamas model of electronic monitoring as outlined in their Penal Code Amendment Act of 2008. Like the Bahamas, this bill allows for the establishment of an electronic monitoring unit which will implement and maintain the electronic monitoring system and comply with the contents of any order issued by the court. Mr. Speaker, I now turn to the provisions of the bill. Clause 1 provides for the short title of the Act and also provides that the Act shall come into operation by proclamation by the President, save that certain provisions would come into effect on different dates. Clause 2 would provide for the constitutionality of the bill, which is divided into 5 parts and comprises 23 clauses. This bill would be inconsistent with Section 4 and 5 of the Constitution and is therefore required to be passed by a special majority vote of at least 3/5 of the members of each House. Mr. Speaker, the Constitution is the supreme law of our land, and any legislative provision which is inconsistent with it is void to the extent of the inconsistency. This is clearly stated in Section 2 of the Constitution. It is well established that in every democratic society that the rights of the individual must be balanced against the interests of national security, the public and economic well-being of the country, and the effective functioning of the criminal justice system. When these interests conflict, the public interest or common good must prevail where reasonably justifiable. It sometimes becomes necessary, therefore, that individual rights are abrogated where there is a threat to the public good. In other words, Mr. Speaker, the rights of each individual must be balanced against the right of the state to protect all individuals collectively. I will now address those provisions of the bill which would be inconsistent with Sections 4 and 5 of the Constitution. I start with Clause 9 of the bill, which which would provide for the court to impose electronic monitoring as a sentence, in lieu of a sentence of imprisonment, as part of a sentence comprising some imprisonment, or as part of any non-custodial sentence, as a condition of bail and as a condition of a protection order made under the Domestic Violence Act. Further, Clause 13 would require a person or a respondent to make full or partial payment for the use of the electronic monitoring device. These provisions would be inconsistent with the right of the individual to equality before the law and the protection of the law, which is guaranteed in Section 4B of the Constitution, respectively. Mr. Speaker, this right is an intrinsic right which every democratic nation must guard jealously. Mr. Speaker, it is important that we understand that the provision of electronic monitoring is not cheap. There is a heavy cost to it. But that cost has to be balanced against the cost to keep somebody locked up, which is one of few options left to a sentencing court today, and also has to be balanced against the ability to a person to pay in whole or in part the cost of that device. You see, what this opens up is opportunity for persons under electronic monitoring to be confined to their home, to be allowed from their home to go to work, to continue to be a productive member of society, to help pay for the electronic monitoring device. Many people are locked up when they could be productive. There are times, Mr. Speaker, and I always say it, and this is something that everyone should understand. You have persons who I would call criminal, people who are perpetual offenders. They can't get out of trouble. They keep stealing. That is their way of life. They steal, they steal, they steal. They are called thieves. They are called thieves. And then you have other people who are driven to stealing out of circumstances, in many instances, created by those on the other side who did not provide work, sustainable work for people. You see? I had to throw that in. So, Mr. Speaker, you have cases where you have a man who has lived a good life all his life. He has never gone foul of the law, respectable into his 50s, and one day somebody insults his wife. He hits them a slap, they slip and they fall, they hit their head, and they die. Okay? That person is not a criminal, but he has committed an act with criminal consequences for himself. Is he a criminal? Should he be taken and thrown in a jail and locked up for 10, 15 years because of that single indiscretion? I think that this country will say no. And while it is that the courts have certain sentencing guidelines, it is only in the rarest and most exceptional circumstance that one would find that a person in that situation would not get a peremptory term of imprisonment. Now you see, imprisonment is really something that is in the mind. You take a person who is accustomed of flying out to all parts of the world